All right, now for our second session today, supply chain disputes, risk, trends, and avoidance strategies. Next slide. I'd like to welcome Amish Patel and Meredith Haynes, our presenters for this session. Amish is a partner in our corporate section and is based out of our Raleigh office. He works closely with large and middle market companies and entrepreneurs to provide business and legal counsel on corporate and transactional matters, including mergers and acquisitions, private equity fundraising, economic development, and corporate governance issues. Amish serves as outside general counsel to companies across a broad range of industries, including life sciences, manufacturing, medical device, and software as a service. Meredith Haynes is a partner in our litigation section based out of our Richmond office. She litigates in state and federal courts with an emphasis on business torts, construction, healthcare, land use, and shareholder disputes, as well as the defense of consumer protection and class action items. Meredith has handled all stages and aspects of litigation, including pre-suit investigation, taking and defending depositions, motions practice, expert discovery, and trial. Amish, I'll turn to you to kick us off.
Thank you, Julia. Appreciate that. Good morning, everyone. We're glad you could join us here this morning. Today, Meredith and I will be talking about supply chain disputes. And our agenda for today will be to cover some common causes of supply chain litigation. We'll talk about some common claims that are raised in litigation or in disputes. And then Meredith will talk about some recent trends she's seeing on the litigation side, as well as some common defenses to contract performance. We'll also touch on some mitigation strategies or strategies to avoid litigation altogether. So we'll talk a little bit about contracts and some of the provisions that you can include or consider including into your standard contracts. And then lastly, Meredith will talk some more about if you are in the unfortunate circumstances of having to litigate, what are some strategies and some case studies that she's seeing around litigation. Next slide, please. So kind of digging in a little bit further, we'll talk about what are the common causes of supply chain disputes. We'll talk about some claims, as well as some operational and legal strategies to cover to minimize disputes, and if you are in a dispute, what are some legal strategies that you can use on the litigation side. Next slide, please. All right, so let's talk about some of the recurring issues that lead to disputes or breakdowns in the supply chain, particularly those that are rooted in the contracting process itself. So we want to set the stage here. The first and foremost, arguably the most important of these is where you fail to get organizational stakeholder buy-in. So what I mean by that is whether it's finance, engineering, procurement, if these key departments aren't looped into the contracting process early, you're likely to see friction down the road. You may get misaligned expectations, you may miss compliance requirements, or even you may have non-approval of deals after the fact. Second, many organizations operate with loose or unclear contracting standards. So a good example is when the sales team is under pressure to close a deal either before month end or quarter end, and they agree to whatever the terms a customer provides them. And so oftentimes these are either given no legal review at all, or maybe some very limited review just because of the time pressures. So the intention is good. They don't want to jeopardize the relationship with that key customer, but the downstream risks can be significant. We also frequently see where you've got multiple overlapping agreements. Maybe you've got a master services agreement, several purchase orders, a couple of statements of work. They're all active at the same time, making it really unclear as to what the contracting terms are. So when the scope, pricing, or responsibilities aren't clearly delineated, you really just have a breeding ground for these types of disputes. Another pitfall I often see is where you've got inappropriate use of standard terms and conditions. And this happens when, for instance, we apply boilerplate terms and conditions for sale of goods, for example, that actually have some kind of installation services component to it, or maybe a software as a service component as well. And so there you can either have a mismatch or create serious gaps in areas like warranties, data security, and liability allocation. There's also often a disconnect between upstream vendor terms and downstream customer terms. So if you're in that middle of the supply chain, for example, you may have locked into strict SLAs or penalties with your customer, but you don't have those same SLAs and penalties with your vendor, right? And so there you're stuck in the middle, and you may have to incur or absorb costs or liabilities that you didn't plan for. We also need to account for the fact that terms and conditions may evolve over time. And so if there's no process for version control or updating contracting templates on an annual or semi-annual or every 2 or 3 year basis, teams may be relying on outdated language. There may have been changes in the law, in the regulatory aspects of it. And we see that most often when it comes to data security and privacy, because that's still currently a patchwork of laws that, at least in the US. And finally, we see cases where parties perform without fully adhering to the contract, right? So whether it's shipping out goods before signatures are finalized or ignoring certain service obligations, this is ripe and opens the door to non-performance claims or limits your enforceability when things go wrong. So in each of these scenarios, they increase the risk of disputes, whether it's internally or with third parties, and they often stem not from bad intent, but there's just gaps in the process, in communication, and in oversight. Next slide, please. So why is this important? When we talk about supply chain disputes, it's not just a matter of legal technicalities, right? It's about real world impacts that can ripple across the entire organization and sometimes across affiliates around the globe. So today's supply chains are fairly complex. They're all interconnected. You may have OEMs, wholesalers, distributors, retailers, and then lastly, you've got end customers. And sometimes you may even have white labeling arrangements and international value added resellers. So that just all creates a complex supply chain where you've got multiple jurisdictions, you've got multiple time zones, and multiple bodies of law that you're working with. When something breaks down, then whether it's a shipment that's delayed, a contract that's breached, or terms are unclear, the consequences can go far beyond just that single transaction. You may have upstream or downstream issues as well. And so when that occurs, you've got your obvious financial harm, things like contract damages, lost revenue, but there's also intangible harm that's often overlooked. And these can be harder to quantify, right? But they can sometimes and oftentimes be more damaging in the long term. So for instance, reputational damage, especially if the dispute becomes public or the disputes disrupt service to a key customer, that can have significant impact from a reputational standpoint and can last a really long time. I also want to touch on what I call mission distraction. So what I mean by that is when you've got a dispute within your supply chain, it often involves significant resources, not just paying outside counsel or having attorneys handle that dispute, but it can also suck away resources from companies' leadership as well as the legal team. And so they can become consumed with resolving the dispute, and it really diverts attention away from strategic and business initiatives and objectives. And then, of course, you've got resources that get pulled away. You've got legal operations, procurement teams, finance teams, all high-valued internal teams that are being forced to play defense rather than offense and grow the business. Finally, there's the geopolitical overlay, right? You've got international and regional conflicts, Shifting trade policies, that seems to be the topic of the times right now. You've got ongoing trade tensions, whether it's tariffs or export restrictions. That can all further complicate contract enforcement and pricing and supply commitments. So what seemed like a stable relationship in one region, they may become unworkable in another. And the takeaway here at the end of the day is, contracting isn't just a back office function. It's a strategic tool to manage risk, to protect revenue, and ensure operational continuity across very fragile and complex supply chains. Next slide, please. So now let's talk a little bit about what kinds of claims we see most frequently. You've got your standard breach of contract claim. This can include for late or non-delivery of products or delivery of services. It can stem from non-payment or late payments, defective quality of the goods, or simply differing expectations due to vague contracting language. You've also got force majeure claims. We all lived through COVID-19, which exposed how different force majeure clauses can operate. Coming out of COVID, we dealt with a lot of supply chain issues, right? Shortages, labor shortages, lack of adequate transportation. Oftentimes, transportation became increasingly pricey, and now we've got tariffs. So these disputes aren't hypothetical. They're actually cases that you may be currently defending or ideally preventing in the first place. Next slide, please. So some other common disputes can be for product liability. So you've got defective goods that affect downstream end customers. That can become especially complex when you've got multiple parties within your supply chain. It can become complex when you're dealing with recalls, whether these are voluntary or mandatory recalls, and third-party claims can escalate pretty quickly. You've also can have disputes around IP ownership, right? So who owns the underlying IP? Is the license broad enough to allow you to use the IP as you intend to use it? Are the software licenses, are they assignable? These are questions regularly fueling these types of disputes. And then lastly, we've got regulatory compliance issues, right? You've got import-export rules, data protection, labor and human rights compliance. These are increasingly non-negotiable and can trigger both regulatory action and private disputes as well. So next, we'll head into our first polling question of our presentation. Next polling question, please. All right, it looks like I'm having trouble seeing it, but so I'll read the question aloud. Hopefully you all can see it. What types of supply chain disputes have you encountered most often? Of the ones that we talked about, the answer choices are breach of contract, force majeure, regulatory or trade compliance issues, IP or confidentiality breaches, non-payment or pricing disputes, or none, right? You may not have incurred any of these so far. So we've got about 10 seconds remaining. Go ahead and get your answers locked in. If you have requested CLE credit, you must respond to each poll, so be sure to get your answers in. All right, we're wrapping up here really soon. Go ahead and get your last answers in. All right, poll is closed. It looks like breach of contract, not surprisingly, is at the top with 43%. Thank you all for answering. And next up, I'll turn it over to Meredith to walk us through some recent trends she's seeing on the supply chain litigation side.
Thanks, Amish, and good morning, everyone. I'm Meredith Haynes, and I'm going to talk about supply chain disputes from the litigation perspective and about force majeure provisions. But first, I wanted to back up and just talk about a little bit about how we have seen supply chain litigation arise in the last 5 to 10 years. What types of events and current events are we seeing give rise to these disputes? And the first is pretty obvious. Over the last several decades, suppliers, companies, entities have worked really hard to be extremely efficient. And that's a great thing, but it also makes supply chains vulnerable to disruption. So suppliers often don't have redundant inventory, and supply chain disruptions can cause orders to fail. Secondly, severe weather, and not just things like hurricanes or floods, which we've seen a lot of in the last couple of years, but Winter Storm Uri in 2021. I worked on a case that arose out of that storm, and that storm prompted a raft of oil and gas supply chain litigation. Of course, pandemics, Amish mentioned COVID-19, and we still are dealing with the fallout and impact on supply chains from the pandemic. These days, military and global conflict goes without saying that those disputes can spill over geographic borders and have impacts on costs and supply chain contracts far beyond where those disputes are actually happening. Regulatory unpredictability is the name of the game these days. And of course, that causes downstream issues. We've probably all heard of suppliers moving and adjusting supply chains to avoid tariffs, or things like the China Plus One strategy, where companies set up additional production or supplier bases to avoid relying solely on one supplier. PFAS is an emerging trend in litigation, and PFAS are the forever chemicals that occur in everyday items like rugs, carpets, plastics, consumer goods. And a really important part of understanding and defending those claims for your company or for your client is understanding where your company or your client is in the supply chain, and accordingly what their duties or lack of duties are with respect to PFAS, how they treat those materials, and or give warnings about them if they are required to. Pharmaceuticals is also increasingly in the supply chain dispute discussion. In 2021, according to the Wall Street Journal, of the top 100 generic meds consumed in the United States, 83% of those medications didn't have a US producer. So there has been an emphasis recently and a discussion in the industry about how to shift more of that production stateside or to alternative suppliers. And of course, that prompts questions about players in the supply chain to create those finished products. And lastly, I'd be remiss if I didn't mention generative AI, an emerging technology. AI is an extremely important tool for supply chains and assisting with data consistency and risk monitoring. And that use, of course, is going to continue to rise and change how business is done. Next slide, please. So, what happens when you or your business partner is in a situation where a contract, because of some event, a rise in costs, a pandemic, a severe weather event, regulatory unpredictability, when a contract becomes not what the parties thought that they were getting, the contract becomes extremely difficult to perform or 10 times more expensive than the parties thought it was going to be performed. What are your options and what are the defenses that you can raise to contract performance? And I'm going to talk about two buckets of defenses to contract performance. One bucket is the common law defenses. These are defenses that are available to everyone. They exist sort of out in the ether. They don't have to be in a contract. Alternatively, a force majeure provision is typically a contracted for negotiated provision in a party's contract. And I'm going to talk about these common law doctrines first. These doctrines are typically somewhat difficult to prove and not always successful. But again, their advantage is that they're available in the event of a contract becoming difficult or impossible to perform. So first of all, frustration of purpose. What does that mean? That could be, for example, where the parties have a contract to lease a building and then the building burns down. There is no building to lease, and an unforeseen event has arisen, which makes the contract impossible to fulfill. So you have a frustration of purpose defense. Impracticability could arise where there is an extreme cost of materials or a shortage of materials that was not foreseen when the contract was made. There's also a UCC analog to impracticability, which I'll talk about on the next slide. There's impossibility. Impossibility is a limited defense, and it's hard to raise because, for the simple reason, it just isn't that much that's impossible in this day and age. It might cost more, it might take longer, but it's just about always possible to overcome whatever event happens to have occurred in the context of a commercial contract. Mutual mistake is where both parties, exactly like it sounds, are mistaken about the same important fact within the contract. So this can be difficult to prove because it's going to be a rare circumstance where both parties are mistaken about the same important fact in a contract, and that's a provable mistaken understanding. And then your remedies, if you are successful on one of these common law defenses, are things like reformation of the contract, changing the contract to suit the circumstances, or rescission, canceling the contract. Next slide, please. This is the UCC provision that I referred to. So the UCC applies to sales of goods, does not apply to service contracts or employment contracts. And this UCC provision excuses a seller from timely delivery of goods when performance is commercially impractical because of unforeseen circumstances. One important caveat to this UCC provision is that it accepts normal business risk. So you can't get out of a normal business risk by invoking Section 2615. And what is a normal business risk? A normal business risk would be an increase in price based on economic conditions. For example, a stock market hiccup, an insurance premium increase in the cost of labor, materials, shipping, transportation, that kind of thing. So this is not a get out of jail free card. It is intended to apply when there truly was an unforeseen circumstance out of the seller's control, not a normal business risk. Next slide, please. All right, force majeure. So this is the other side of the defense to a contract performance coin. You have your common law defenses on one hand, force majeure on the other hand. Generally speaking, a contractual force majeure provision allocates risk of non-performance due to events beyond the party's control. That is the function of a force majeure provision. Beyond that, a force majeure provision is what the parties negotiate and bargain for and eventually put in their contract. So, like I said, the common law defenses are harder to prove, but the advantage is that they are a little bit more flexible. They don't delineate qualifying events. The terms of a common law defense don't have to be agreed to by the parties, unlike with a force majeure clause. Common law doctrines are commonly asserted alongside a force majeure defense because they can cover reasons for non-performance that may not expressly be covered by the force majeure clause. An important thing, the most important thing to keep in mind with a force majeure provision, like any contract provision, a court is going to interpret it as written. So it will define the scope of the unforeseeable event that might excuse non-performance. It will describe the relief available. It will set forth duties of the party asserting force majeure to mitigate the effect of the event, and it will establish conditions precedent to relief, such as giving notice. One temptation when you see all of these things that a force majeure provision may define or quantify or apply to is to keep your force majeure provision as simple and boilerplate as possible, but there are risks to that also, which I will discuss in a little bit. But for now, I'm going to turn it back over to Amish to talk about minimizing litigation risks so that you don't have to invoke these types of defenses.
Thanks, Meredith. So let's jump into ways to minimize litigation risk. And so I kind of lump these into two buckets, right? So you've got your what you can do from an operational standpoint, and then we'll talk about some legal things or legal tools that we can use to help mitigate litigation risk. And so the first thing is, supplier due diligence and audits, right? So making sure that there's credit checks being done on suppliers, uh, making sure that before signing the contract, you know that the supplier is financially sound. And so credit checks and financial assessments can alert you to red flags before you've even signed on the dotted line. Along with that, conducting factory tours, right? So there's really no substitute for seeing things firsthand. And it gives you a chance to evaluate not just capacity and quality controls, but also just the general workplace conditions of your suppliers. And then we've also got trials and sample testing. So you may be getting ready to place a large scale purchase order, and so before you doing that, you may want to conduct sample runs or test trial shipments that can validate that the supplier can actually meet your specifications. This will obviously prevent costly disputes later on if quality or performance becomes an issue. Next, you've got compliance programs and training. So making sure that the right staff are trained, whether it's procurement, sales, operations teams, they understand what the contractual requirements are. That can also help them, identify issues earlier rather than later, which theoretically should, and practically speaking, should minimize your litigation risk. And then once they're trained, you want to have a process or a program for ongoing compliance and monitoring. Supply chains are dynamic, so suppliers' practices can change over time. And so maintaining or monitoring supplier compliance with terms and regulations and standards will go a long way throughout the relationship. And at the end of the day, you want to make sure that you've got some kind of contractual inspection or audit rights built into your contracts. Think of these as the teeth behind your compliance efforts. Not only is it a deterrent for suppliers, but it also can check for issues before they escalate into larger problems. Next slide, please. Some other things to consider from an operational perspective is making sure you have a good understanding about cybersecurity and data protection requirements. A lot more and more of the supply chain incorporates some kind of personal data. So ensuring that you understand what's the type of data, where is it going to be processed, is any of it going to be processed overseas, and what laws apply. Having a good understanding about that will ensure that there's fairly low risk in the future. Also, insurance strategies also play a role, right? So beyond just the standard general liability coverage, you may want to consider having coverage for product liability or trade disruption insurance as well. And then I think proactive contract management, that's the key here, right? So too often you sign a contract, it gets filed away, but revisiting that on a regular basis will uncover or prevent any disputes later on. And lastly, you want to make sure your payment terms are aligned with milestones or completion of work. I'd say this is one of the most effective ways to reduce litigation risk. If payment terms are tied to performance, whether it's delivery, quality, acceptance, or project completion, you as a customer can maintain that leverage. Next slide, please. So now let's jump over to some legal tools or legal ways to minimize litigation risk. We talked about operational things. So what can you do from an in-house, if you're an in-house counsel or an attorney or general counsel with your client? So the first thing is having a good foundation of clear terms and conditions. Ambiguity is a fuel for disputes. So having contracting clarity is critical. And along with that, a common decision point is whether to use tailored contracts or rely on standard terms and conditions. So tailored contracts, they take more time to negotiate, right? There's a little bit more back and forth involved with your supplier, but they allow you to address unique risks that are unique to your industry or to your offering, whether it's a product or service or some kind of a SaaS component. On the flip side, though, standard terms and conditions are much faster. You can close these relationships or these deals much quicker, but they may not adequately cover any high risk transactions that you're seeking. Next thing, it's important to get organizational buy-in, right? So making sure that legal does not work in a vacuum. You want your product teams, engineering teams, QA, finance, procurement, they all need to be aligned. And the contract, whatever contract you're using, it needs to reflect that. Next up, we have making sure that your indemnification obligations are harmonized with your warranties and limitations of liabilities. That's critical. You want to make sure that all of these work hand in hand to prevent or minimize litigation risk. Next slide, please. So you also want to be deliberate about forum selection and dispute resolution mechanisms. We'll talk about these here in a little bit, but you want to make sure that that aligns with your industry, and you're thoughtful in determining, how to select the proper forum and what's the right dispute resolution mechanism that makes sense for your organization. And finally, consistency across documents is essential. Many disputes arise, like I said earlier, when you've got multiple agreements with the same vendor. So you've got MSAs, statements of work, and POs. They all contain different terms. They all conflict with one another. And so understanding that, maintaining contractual hierarchy and using some kind of order of precedence clauses will avoid confusion by your operational teams. So the overarching principle is going to be, having well-structured contracts, and to use them as a tool for minimizing litigation risk. You want to focus on clarity, internal consistency, and alignment with business priorities. Next slide, please. So now let's drill down into some key risk allocation tools. First and foremost, you've got your indemnity clauses. These are the core, right? So it's about transferring or allocating financial risk between the parties. And so if something goes wrong, whether it's a product defect, IP infringement, or a regulatory violation, the indemnity clause determines who's going to bear that cost. So understanding the scope of the indemnity, who is indemnified, which claims are covered, and the triggering language. So whether it's arising out of, solely resulting from, or in connection with is important. Be clear on the indemnity, on duties to indemnify, defend, and hold harmless, and how they differ. Another contractual tool is your standard limitation of liability clause, right? So think of this as a way to define the financial boundaries of a party's exposure. Without it, even a small contractual breach can spiral into outsized damages claims. These clauses determine what types of damages are recoverable, so how damages are capped, and whether it's by contract value, a multiplier, or some predefined damages cap. And then you also want to pay attention to what exclusions apply to that cap. You've also got warranties and representations, right? So these allocate risk between the parties, often serving as the basis for also termination rights and indemnification. While contracts distinguish between reps and warranties, courts often treat them interchangeably. You've also got termination rights. These can be for cause and for convenience. And then upon termination, what are the effects of termination? And that should be addressed with precision as well. You'll also want to consider remedies, and we'll talk about this on the next slide, as well as dispute resolution mechanisms, which we'll also cover next. So remedies, these are the tools available to enforce obligations or address any breaches in your supply chain agreements. Starting with equitable remedies, these are non-discretionary remedies that courts may award when monetary damages are insufficient or unavailable. So the most common examples are specific performance and injunctions. Specific performance compels a party to fulfill its contractual obligations, and injunctions, on the flip side, prohibit a party from taking a certain action. You also want to determine whether equitable remedies are powerful, but they also, you want to talk about, address whether you've got cumulative versus exclusive remedies, right? So cumulative remedies allow a party to seek multiple remedies at once, whereas exclusive remedies kind of limit recovery to the predefined remedy that's covered in your contract. I also want to highlight liquidated damages. That's also another tool we are seeing more and more in supply chain agreements. These are pre-agreed amounts payable if there is a dispute. And so they're often used when it's difficult to quantify what damages could be if there was a dispute. And so the parties will take the time up front to kind of set whether it's a formula or some kind of multiplier of what those damages could be. And finally, we touched on indemnification. That can also be served as a remedy mechanism. It allows one party to cover costs or losses from the other, typically as a result of third-party claims, or it could be for breaches of reps or warranties as well. Next slide, please. So now let's set the stage. You've got a dispute, and you turn to the contract to determine what are the dispute resolution mechanisms that are built into the contract. And so the first step, and what I typically like to include is where you've got the management involved, right? So this is often the first step of having senior leadership or CEOs or your chief commercial officer or operations officer handling these disputes, working with the counterparty to come up with a resolution. It's by far the fastest and the most least expensive way. And it also helps preserve that relationship you've got with that supplier. If that doesn't work, folks often look to mediation, which is a non-binding process that brings in a neutral third party to help the parties come up with a settlement. They don't really impose a decision, right? Instead, they focus on facilitating dialogue between the parties and trying to help the parties come up with a mutually acceptable solution. And then we have arbitration. This is a little bit more formal, I'd say, than mediation, but it's generally faster than litigation and a little bit more flexible. And arbitration can have a sole arbitrator or it can be a panel. And you typically decide, the arbitral bodies of law or the rules around arbitration up front in your contract, as well as the physical location of where that arbitration would be held. And that's often important, especially when you're dealing with suppliers that are international or based overseas. Next slide, please. And finally, there's litigation, right? So this is your traditional route for where decisions are made by courts. It provides an avenue for allowing formal discovery and then creates enforceable judgments. But then on the flip side, it can be slower. It can be expensive. But I think at the end of the day, you can use a combination of these approaches. But at the end of the day, you want to make sure that you've got some kind of mechanism in place that aligns with your organization. And so next up, I'll turn it back over to Meredith, who will talk about some litigation strategies.
Thanks, Amish. And so what do you do when all of the good contracting and business practices Amish covered either haven't been observed or don't work, or your client or your business face a truly unforeseeable or catastrophic event, and you're trying to decide, well, should we invoke force majeure? Is this something that warrants going to that provision of the contract and invoking force majeure. And it's important to take a step back and consider the question for two primary reasons. The first is whoever invokes force majeure bears the burden of proving that whatever event has occurred falls within the provision that you're invoking. Unfortunately, you can't invoke force majeure and walk away and let it speak for itself. You are oftentimes going to have to prove that the event you're invoking the provision for qualifies under the relevant provision. And the second reason is that most of the time, when one party invokes force majeure or a common law defense to contract performance, the next step is a breach of contract claim from the other side. So invoking force majeure is not a risk-free strategy, and it pays to ask these questions before going that route. So first of all, does the event qualify? And it's worth asking yourself this question because just because the event is extremely inconvenient or makes things extremely expensive doesn't mean that it's unforeseeable or that it falls within your force majeure provision. So for example, there was a case in Michigan a few years ago where one party invoked force majeure because the FDA inspected a plant and closed it down. Just because the FDA doesn't usually inspect that plant, just because the FDA doesn't usually shut down the plant, doesn't mean that it's unforeseeable. And so that's not a force majeure event in the facts of that case. Has the party invoking force majeure met any preconditions? So a lot of force majeure provisions, some of which we will look at, require things like due diligence to avoid force majeure or to provide substitute goods. Has the party invoking force majeure provided notice? Most force majeure provisions require the invoking party to give a certain kind and a certain amount of notice. And if you don't follow those provisions, then you can lose the protection of the provision. Next slide, please. This is our second poll question, and I'll give some background as I go through the slide. But the question is, do the contracts that I'm about to talk about require Dynegy, the defendant and the gas supplier in this case, to attempt to secure replacement gas to Ergon, the plaintiff? So there were two contracts between these parties. One said that a force majeure provision can only be invoked if the party remedies with all reasonable dispatch the force majeure event. The other included a force majeure catch-all that defined force majeure as an event that you can't overcome with due diligence. So when Dynegy's upstream suppliers declared force majeure themselves, and Dynegy went to Ergon and said, look, our upstream suppliers aren't giving us gas, we can't give you gas, too bad, was Dynegy required to secure replacement gas in that instance? And you have probably a few more seconds to answer the poll. And as a reminder, it doesn't have to be correct. You're not getting graded on these polls, but you do have to answer them to get credit for the CLE. 10 seconds remaining. And poll is closed. So most of you, 67% said yes, 33% said no. And I agree that the common sense resolution here would be if you have force majeure provisions that basically say you need to exercise some diligence to find replacement gas, then you should have to go out and find replacement gas because you're going to be able to. It's just going to be more expensive. But in this case, Dynegy had expert testimony on both contracts that said to the court, if your upstream suppliers declare force majeure in this industry, then it's common and it's industry practice to go to your buyer and say, sorry, you're out of luck because I'm out of luck and I don't have to go buy replacement gas for you. So another thing to consider before you invoke force majeure or in the process of invoking the provision is to ask yourself, do I need expert testimony to either bless what I'm doing or explain to the court why this is common practice in the industry, notwithstanding these contract provisions that require me to exercise due diligence? Next slide, please. So these cases in the higher education context, so a little bit outside of supply chain issues, but this was an interesting development in the interpretation of force majeure provisions, so worth mentioning for its potential effect in the future. students were suing their universities for shutting down class during the pandemic. And I think, when we all went to college, none of us signed a contract that had a force majeure provision in it, right? But you did have things like student guidelines or undergraduate regulations. And so courts, mainly the Second Circuit, a lot of these cases were in the Second Circuit, sort of worked to find an implied force majeure provision between the students and the university that would allow the university to cancel classes in the event of something like a pandemic. And there were limitations in cases. There was one involving NYU, where NYU gave itself basically unfettered discretion to shut down class for any reason at any time. And courts weren't willing to go that far and say, okay, fine, that's a force majeure provision. But in circumstances like the Michelle versus Yale case, where Yale had a provision that sort of said, in our judgment, if something happens, we reserve the right to suspend classes. Courts were willing to reach a little bit and find that this is a force majeure clause, that the university successfully invoked it as a defense, and that the students' claims could not go forward. So it'll be interesting to see if this type of extension of force majeure as a concept in implied contracts could be extended to other contexts outside of higher education. Next slide, please. Force majeure and government action. So very typical lawyer and litigator answer is that it depends, but government action cases are very fact dependent. So I talked a little bit about how just because something's very inconvenient or very expensive doesn't make it unforeseeable or impossible. So it really depends on what the government action is. If it was foreseeable, and typically in the past, courts haven't considered regulatory or policy changes such as tariffs or environmental regulation to be a qualifying event, because government regulation and policy change is foreseeable, inconvenient, expensive, but foreseeable. It'll be interesting to see if, given unprecedented or extremely unusual government regulation or action, if there will be more of a strong force majeure defense in those circumstances. Next slide, please. COVID-19 and supply chains. So this case dealt with an order for 8 million gloves, PPE, during the pandemic. And this case dealt with a supply chain where Wipeco contracted with Bluestem, who in turn contracted with Sunshine Garden, a Chinese manufacturing firm. And Sunshine Garden ran into manufacturing problems and they weren't able to come up with the 8 million gloves. So Bluestem did its best, tried to find substitute suppliers, ultimately did find substitute suppliers, but it was going to be on a much longer time frame than the contract contemplated. And we all heard about these types of situations during the pandemic where orders for things like masks or gloves or other PPE were delayed and hard to come by. So when Bluestem couldn't provide the 8 million gloves on time, Wipeco sued them and Bluestem asserted force majeure among other defenses. So we talked about the considerations that one should make before invoking force majeure and all of the details that a force majeure provision may provide. Notice, qualifying events, things that one might have to do to avoid force majeure before invoking it. On the other side of the coin is a boilerplate force majeure provision like the parties had in this contract, where it basically just says, couldn't get more vague than this, force majeure may apply because this is a very volatile industry. And so this force majeure provision, because it was so vague, ended up being useless to Bluestem. The court held that this wasn't enforceable and they could not rely on may apply because this is a volatile industry as a way to get out of this contract. So Bluestem had to fall back on impracticability, a common law defense, which also didn't apply because in this case, the court found that it wasn't really impracticable or impossible for Bluestem to find the gloves. They just didn't find them on the timeline that they were supposed to. So one interesting aspect of the supply chain issues that were encountered during the pandemic is that as the pandemic went on, courts were less sympathetic and less willing to find supply chain disruptions unforeseeable because what may have been unforeseeable in 2020 or maybe even 2021 was foreseeable in 2022, 2023, and suppliers like Bluestem had to have planned for these contingencies by having other suppliers or perhaps working more flexibility into their contracts so that they didn't end up in this situation. So, lesson here is that while a detailed force majeure provision can create issues and requires some thoughtful drafting and negotiation, a boilerplate force majeure provision isn't going to do anything for you. Next slide, please. So back to Winter Storm Uri. This is a situation where Pioneer was supposed to supply gas to MECO. Pioneer sort of stopped during the storm in February of 2021, explaining the gas, and then without an explanation, just stopped entirely. MECO went out onto the spot market and purchased replacement gas to the tune of $9 million. And then MECO came against Pioneer and sued Pioneer for breach of contract for that $9 million that MECO had to go out and spend to get replacement gas. So these parties had a force majeure provision, which said that a force majeure event is an event which prevents one party from performing obligations which was not anticipated and which by the exercise of due diligence is unable to overcome or avoid. So this is a little like the Ergen or and Dynegy case. How could it not, how could you not be able to overcome this event if Pioneer, the plaintiff, was able to go out and get the gas? It was just more expensive, right? It was able to be done, but it was more expensive. So the plaintiff, MECO, sued Pioneer at the district court level. Pioneer won. The court found that the force majeure provision applied and Pioneer was able to get out of its contractual obligations, and MECO appealed. And on appeal, MECO won because the appeals court looked at this provision and asked, well, what do these words that you've put in your force majeure provision mean? These words have created fact issues as to whether Uri prevented performance or whether Pioneer made reasonable efforts to overcome Uri's effects. So there are fact issues here that have to be determined, and you can't get summary judgment. So lesson here is that a force majeure provision is not always an easy fix. You can add these words to kind of couch a party's ability to invoke this get out of jail free card, but then you may end up in litigation all the way to trial because the parties have to go through discovery and determine factual disputes at trial over what things like prevent means or what due diligence requires. Next slide, please. So some lessons from specific cases invoking force majeure and how courts have treated those provisions. How can one determine the potential success of a force majeure clause? So it depends on the contractual and common law obligations, right? It depends on what the parties have agreed to in their contract. If there's a specific force majeure provision at issue, it depends on if you're asserting common law defenses, if you truly have the facts to support those defenses, if it truly is impracticable to perform the contract, if there really is a mutual mistake or a frustration of purpose that prevents performance of the contract, or are you just trying to overcome a really inconvenient price development or supply development that perhaps wasn't drafted for or anticipated in your contract? It depends on the good or service provided. So there tends to be a much stricter approach to a tangible concrete good like an order for 8 million gloves than for a less tangible relationship and good between the parties like a collegiate education. Of course, it depends on the severity and foreseeability of the underlying event. So we can generally assume that the government is going to make regulations that change parties' relationships to each other and change the terms of a contract. That's going to be hard to prove unforeseeable, whereas you might be able to describe as an extreme weather event as truly unforeseeable. And then what is the method of supply and alternatives? Basically, what industry are you in? So I think it's pretty well established that in the oil and gas industry, you can almost always go out and get oil or gas. It's just a matter of what the expense is going to be, and how the gas is going to be obtained, versus a tangible good like Love's, where there probably is another supplier. You're just going to have to find it, and there may be a different timeline, or a more unique good where there really isn't going to be a replacement, especially not on any kind of timeline. So all things to take into consideration. And with that, I'll hand it back over to Amish for some closing points and takeaways.
Thanks, Meredith. So I know we covered a lot here today, this morning, but I wanted to kind of walk through some takeaways. So, making sure you've got strong contracts where various stakeholders in your organization have reviewed, have provided input on is critical, right? So making sure things like you're thinking through reps and warranties, IP provisions, financing terms, as well as specifications around certain goods or the scope of services. You want to make sure that you've got buy-in from all the stakeholders. That way, if there is well, one, it can minimize disputes, but two, if there is a dispute, you've got a clear pathway to resolve that dispute. And then the other takeaway is, making sure you're conducting risk assessments regularly and preparing mitigation plans. And so if you're going down the pathway of litigating with a supplier, you want to make sure you kind of thought through those plans ahead of time, and have a game plan of how to strategize for that dispute. So that concludes our presentation. We are right at time, surprisingly. We may have question for one quick question before time is up. So the first one looks like it's Meredith for you. Which clauses are you seeing most frequently litigated in supply chain cases?
Sure. So most often the issue that comes up is whether a party satisfied the conditions precedent to invoking force majeure. And a lot of times that's because legal wasn't involved, or the business and legal weren't talking, or people were moving quickly because of course you're in a unforeseeable and difficult event. But when it gets to litigation, that becomes really important. If there was a notice provision requiring one party to give notice to the other and in a specific way to a specific person, if there were other things that had to be done before pulling the ripcord of force majeure, those things have to be done for that provision to be effective at all. And you will lose at the dispositive motion stage early in the case if you haven't done those things.
Great. Thanks for that. Well, it looks like we are right on schedule and out of time here. So if you did ask a question that we didn't address today, we will be happy to reach out after the program and follow up with you directly. Thank you for joining us this morning. You're now headed into looks like a 10-minute break. And after the break, you'll hear from Clinton Brannon and Janet Cho on intellectual property in the age of AI, challenges, opportunities, and open questions. See you back at 11:30. Thanks, everyone.
Thanks all.